This is Barry Zalma on insurance. This is part 2 of a video explaining how to deal with catastrophes like the polar vortex. When presenting a claim with regard to a catastrophe, sometimes the most important part of that presentation is your first contact with the adjuster. And it should usually be an informative meeting where you discuss the cause of the loss, the type of loss, when the loss was discovered, and make an initial effort to agree on a tentative scope of loss. You should expect the adjuster to do the following. 1. Ask for a walkthrough inspection of the entire dwelling or building remaining after the catastrophe. At that walkthrough, you should make every effort to point out each item of damage or suspected damage that is visible during the walkthrough inspection, and you or your representative should assist the adjuster in viewing both the damage and the source of the damage. 2. The adjuster will ask you to submit to a recorded statement. This is where he sits down with a tape recorder or an electronic recorder or even his cell phone and asks you questions about your policy and the claim. It is something that should be automatic and non-confrontational. 3. He will ask you for the identities of each family member or vendor who can give the adjuster information about the loss. 4. The adjuster will ask for the recorded statements of the persons identified. 5. The adjuster will ask permission to allow experts retained by the insurer to inspect the property and do minor destructive testing to establish the appropriate methods of reconstruction and repair. And 6. The adjuster will ask permission to contact others who know information about the loss and to obtain from those people within your control a detailed recorded statement and documents relating to their knowledge of the loss and the extent of the loss. You must understand when dealing with a claim that an adjuster is a person professionally trained to assess the damage to your property. He or she will probably visit your home or business before you are asked to complete any forms. The more information you have about your damaged home or business and belongings, the sooner your claim will be settled. Your adjuster generally will come prepared to do a thorough, complete evaluation of the damage to your property. If the adjuster is unable to complete a thorough inspection due to time constraints or the extent of the damage, he or she should prepare a scope of loss report. This is a brief listing of the findings of damage determined at the initial inspection of the damage. The adjuster should ask you to agree to the scope of loss determined at your first meeting. Agreeing to a scope of loss is not presenting a claim, nor are you compelled to limit your findings to the scope of loss or your claim to the scope of loss. As time passes after the catastrophe, it is common to find additional losses and damages. It is understood and will always be understood by the adjuster that the scope is incomplete and will be added to as new damages are discovered. It is usually supplemented with a second visit after the reports of experts are received to complete the inspection. The scope of loss should include the following: the degree of damage, a description of each location where damage was observed, a description of the adjusters and your own best estimates of the type of damage observed, a list of all personal property damaged or destroyed, the quality of the materials and workmanship and measurements needed to calculate quantities, including length, width, and height of rooms, and the number of openings, such as windows and doors, in each room. The scope of loss, usually referred to by claims people as the scope, differs from the finished estimate in two ways. One, the scope does not necessarily list any prices, although prices can be used to describe quality. And two, the scope does not list the calculated quantities. It includes just the raw counts and measurements needed to calculate quantities for the estimate. The adjuster will work with you to protect all of the property from further damage because every policy requires that the insured protect the property from further loss. Therefore, you should turn off any water flow to broken appliances or frozen pipes, arrange to have openings in roofs or walls covered to protect from rain damage, and seek help from the adjuster to further protect your property from losses of all types. You, as the insured, are expected to take any necessary emergency measures to protect the building and personal property from any further damage. Do not throw anything away until permission of the insurance company is obtained in writing and you have documented its condition. You need not keep any damaged property that presents a hazard to the health or safety of you, your family, or others. If the insurer delays or refuses to authorize measures to prevent further loss, confirm the insurer's delay in a fax, email, and letter, and take whatever reasonable measures you can afford to protect the property. If your loss is covered, the insurance company should also cover the cost of any reasonable emergency measures you took to protect the property. It is not unusual for an insurer to deny coverage for damage resulting after the initial claims on grounds that an insured failed to comply with a policy condition to protect the property from further damage, and you must do everything possible to avoid such an useless and unusual denial. It is also your obligation as the insured to document the loss. If you were prudent and prepared before the catastrophe, an inventory of your contents, or if you took pictures of your contents, will provide the adjuster with the inventory and photographs or a videotape. Your photograph, videotape, and inventory of all damaged property after the loss should also be prepared. Make sure you record the date of the photos and the videotape. It is important to document the source and extent of damage, whether by fire or water intrusion, by snow, ice, or flood entering the property. If your photos or videos are electronic, be sure to store the records off-site, in the cloud, or with entities like Dropbox, Box.com, etc. In most states, a material misrepresentation, concealment, or omission made in connection with the claim will give the insurer a valid reason to reject the entire claim. For example, claiming that an item was destroyed that really wasn't, or substantially overstating the value of a damaged item is fraud. In most states, insurance fraud is a felony that can place you in state prison if convicted, so don't try. Just provide a claim of what you really lost. No catastrophe is so bad as to cause you to attempt to defraud your insurer to make up for uninsured or underinsured losses. You should never exaggerate, speculate, or guess about the loss or value of any particular piece of property. Make it clear to your insurer when recollection may not be accurate, when you are estimating value, and the basis for your estimate. For the value of items you are not sure about on a claim presentation, use the phrase, "to be determined." If you do not have receipts to show the price of an item, information can be found in catalogs, statements from retail clerks, bank statements, credit card statements, statements from family members or friends, Google, Bing, Amazon.com, or any other internet sources. If all else fails, a formal appraisal can be obtained from a professional personal property appraiser or real property appraiser. You should save this option as a last resort, since the insurer will usually refuse to reimburse you for the cost of hiring an appraiser, but may hire one at no cost to you if asked courteously. You, as the insured, are required to cooperate with the insurance company's investigation and handling of the claim. You have a contractual obligation to cooperate with the insurer in its investigation. However, you never have an obligation to allow yourself to be abused. In most states, the insured and the insurance company have a mutual obligation to act in good faith and deal fairly with each other to investigate and process the claim. Neither you nor the insurance company may do anything to prevent the other to obtain the benefits provided by the policy. This means that both should avoid taking any unreasonable position or doing or saying anything that would in any way frustrate each other's rights under the policy. The insurer may require one or more recorded statements from you. Always request a copy of the recording, whether digitally or by a transcript on paper to review. When the recording is complete, ask the adjuster to break out the tab on the tape if he is using a tape so that nothing can be recorded over the tape, and place your signature and date on the tape's label. If recorded electronically on a smartphone or other device, ask for an electronic copy of the statement and a copy of a transcript if one exists. Repeat your request by email, letter, or fax. You have a right to review and correct the transcript of any recorded statement. You may also be required to appear for an examination under oath. The insurer may, but is not required to, hire an attorney to take the EUO to represent the insurer. Since a lawyer is not required, if you retain a lawyer to represent you, the insurer will not pay for the attorney that is representing you. You should not appear for an EUO until you understand all of your rights, the insurance coverage, and the full extent of the claim, or until you retain counsel. Do not refuse to appear at an EUO, or the insurer may reject the claim because such refusal is a breach of a material condition of the policy. You may reasonably request a delay in appearance at an EUO to obtain the services of counsel or a public insurance adjuster to assist you. The insurer may ask you to make available various documents related to the claim, including banking statements, investment reports, receipts, and other personal financial documents. You are required to produce any documentation reasonably related to the insurer's investigation of the claim. That could even include tax returns. In some states, tax returns are considered privilege and the insured cannot be compelled to produce them, while in other states the failure to produce tax returns is sufficient cause to deny the claim. You must check with a local lawyer to determine what your rights and obligations are in that regard, depending on the state where you reside or where the loss occurred. The insurer can require you to produce these kinds of documents as long as they are reasonably related to its investigation and exist, since in many catastrophes, most of your documentation will be destroyed. Often documents needed to are destroyed by this kind of catastrophic losses, and the EUO is used to allow your sworn testimony to take the place of the documentation destroyed by the catastrophe. You should not provide these documents to the insurer until you understand the rights, duties, and obligations imposed by the insurance coverage and the full extent of the claim. You should never refuse to produce documents unreasonably, since the requirement for document production is a condition precedent to the insurer's obligation to provide a defense and/or indemnity to you. This is the end of part 2 of how to present a claim with regard to a catastrophe and/or the polar vortex. Please subscribe to my Rumble channel, my YouTube channel, and my blog so you can see all of the videos relating to the subject of dealing with a loss in a catastrophe. You may also find it useful to consult with the insurance claims library, which includes a listing of all my books with regard to insurance claims at my website, zalma.com. Thank you for your attention.